party, Shiv Sena, for forming the government with NCP and INC, who are ideologically opposed to our party. There has been a compromise on the principles of our party, Shiv Sena, which has been a party of fierce ideological base and was formed for fighting for the rights of local Marathi people. For the last 2.5 years, our party and its leadership have compromised party principles by aligning with the contrasting ideologies for the sake of achieving power. The ideology of our party leader, late Balasaheb Thackeray, was to give a clean and honest government to the people of Maharashtra, and also without compromising on the principle of Hindutva, which was defeated on the first day itself by aligning with the opposing ideologies. Shiv Sena and Bharatiya Party has forged a pre-poll alliance for 2019 Maharashtra Assembly. They sought the blessings of the voters of the Sena BJP alliance, which the voters accepted and voted in favor of alliance. After results were out, the Shiv Sena severed its ties with the BJP and formed an alliance with the opposing parties, which they had fought against in 2019. This act of our party leaders had a tremendous negative impact upon the voters and the party cadre. There was a continuous hue and cry towards party leadership for the act of aligning with the opposing parties. Ignoring this, party leadership went ahead and formed the Maha Vikas Aghadi government. For the last 2.5 years, we, the Shiv Sena legislative party members, were facing tremendous pressures from the electorate. We, the members of the legislative party, as well as all leaders and workers throughout the country, were facing a lot of humiliating questions. Our leader, Balasaheb Thackeray, was always a strong nationalist. We've also been subjected to a lot of criticism for being part of the corrupt Maharashtra. In view of the above, the members of the Maharashtra Shiv Sena Legislative Party have met today and resolved this under. What have they resolved? Hereby resolved and reaffirmed that Shinde, who was appointed as leader of Shiv Sena Legislative Party, is and continues to be the leader of the Shiv Sena Legislative Party of the 14th Maharashtra Legislative Assembly. And this is what is proposed and seconded by members of the legislature. And I hereby further resolve that Bharat Gogavle, elected and appointed as Chief Whip of the 14th Maharashtra Legislative Assembly, is cancelled with immediate, and Sunil Prabhu is cancelled with immediate effect, proposed and seconded. Now, Malas, there is no reference to any meeting of the party. There is no reference to any grievance made prior to this date. They are all members. He was serving as a minister for 2.5 years. There is no reference to any grievance that he has ever had. No reference. No reference to any statement he made in any organizational election. No reference. suddenly could not have happened on the 21st of June, Malas. This sudden realization that this great injustice has been done, Malas. Obviously, this was planned. Whereas if anybody had any grievance of this nature, it would be in public statements, it will be in organizational meetings. After all, this is from 2018, we are in 2023 now, Malas. Not a single statement anywhere. So obviously, and what this statement is being made from Assam. Why Assam? So it's not something, it's all pre-planned, it's a conspiracy. It's not something that happened overnight. And you're talking about poll promises. Let me, Malas, talk of history then. Malas, the poll promise was broken at the time when Malas, Devendra Fadnavis and Ajit Pawar were sworn in the early hours of the morning by the governor. What about that poll promise? So let's not go into politics.
I was just going to say that now you are trenching into politics.
No, but this is all politics.
You're now leaving the area of constitution.
No. I said it in the context of the grievance that he has made. He has made a grievance of poll promise.
No, we are not at all, Mr.
Yes.
But if you not.
So, Malas, let's go. That's why I said we are. I'm sorry.
Yeah,
But therefore, Mr. Sibbal, ultimately, I mean, we're just sort of pushing your argument to its logical conclusion in constitutional terms.
Yes.
Therefore, what you are saying is that, look, when Eknath Shinde was nominated as a group leader and the whip was then nominated, the whip was also notified. It was at the behest of the party,
Yes.
albeit at the MLA's meeting.
Correct.
An alteration of that position was made at the meeting which was chaired by Mr. Uddhav Thackeray. The legislators could not have either abstained from the meeting, which was convened by the party president, nor could the legislators have replaced the whip or the group leader.
That's correct.
So that all that they did was really therefore was contrary to law and therefore invited a disqualification under the 10th schedule. All this really then leads us to this, that therefore they have incurred
The disqualification.
they have incurred a disqualification.
That's correct.
Now, having said that, therefore, this is therefore a case where the speaker has to ultimately decide upon the disqualification which they have incurred, isn't it?
Absolutely.
I understand.
That is, Mr. Sibbal,
what
that is
we-
an area which we are not able to come to bridge.
I will, Malas, I will. Yes. Yes. Yes, I made that argument. Malas. Yes. I will try and, Malas,
Of course, the constitutional position of the speaker to decide.
Malas, I tell your lordship the problems in that area. But kindly
There's
just,
problems in the area, we see that. But,
We understand.
also we understand the significance of the point which you have made, which is a very significant point for constitutional democracy, that ultimately the party is supreme.
yes,
And legislators get there into the House or the Parliament or the Legislative Assembly on the mandate of the party, what the party means to the people.
correct.
Therefore, you are really elected as a representative of the party. Your behavior must be governed by what the party dictates.
Yes.
And a group of legislators, whether you are 1/3 or 1/10
Doesn't matter.
or even 75%,
That's right.
cannot be really determinative of the wishes of the parties. You can alter that position if the party authorizes you, or
Correct.
you leave the
Correct.
party.
Correct.
So far, so good. I mean, that's a very significant point which you have made. But
I understand.
the
point is-
point,
The
the
next
next
point.
point. I mean, what is the consequence?
Yeah, I will, but I'll
That
find
is-
attempt.
Which you are really telling us that, look, the facts stare you in the face. Now, why go to the speaker?
Yes, that's what my submission is. What is
There are
it
two
that the
folds.
speaker is going to do in this?
It could be twofold. One, as you say, well, the speaker himself cannot be trusted as an impartial arbiter.
I withdraw that, Malas, because we are talking about the constitutional
That's
position.
right.
Malas.
The second would be where the facts are so clear.
Yeah,
Then you take the decision where the
Yeah.
speaker ought to have decided that there is only one and one conclusion.
that's right.
That, Mr. Sibbal, honestly,
Speaker
that
has to
is
decide.
that is a matter of disquiet for speaking for myself. I mean, should the court be taking into that, entering into
well,
that area? That's an area of
Your lordships have been persuaded in the past. I hope to persuade you in the
That-
future as well.
there are very serious ramifications. Just
but
as
then-
you know, the ramifications.
I will, Malas, address your lordships on that.
The ramifications which you have referred to for constitutional democracy, if individual legislators start bucking the party discipline, There are very serious ramifications if we start taking over these functions.
Very dangerous.
No, Malas, what happened was,
Very,
in one particular case, which is the Constitution bench, Malas, where they said that this illegality cannot be continued even for a day. So we will take the decision.
because
They are occupying the post of the minister. This cannot continue even for a day. I will not send it back. We will.
Right or wrong, this is the system which we have now assumed to ourselves as we the people. And when the courts try and breach the system, it's a very
No, Malas, I understand.
that's what is worrying us. I mean,
Malas,
put it to you right up
Quite
at the
frankly,
forefront.
a constitutional court should be worried, because if you create this as a precedent, it can happen in other situations as well, and that not be a good precedent. But I am not disputing that. Please, I'm not. I know the limitations of a constitutional court. I know that, Malas. But what has happened in this case, unfortunately, is that this has happened because of a judicial order. This would never have happened.
All right, we also go to this extent that, if a situation transpires because of a judicial order, we are not saying that it has.
Yes,
we are
I
for the-
understand that.
for
I
the
understand.
your argument.
Yes.
And therefore, it's the duty of a court to rectify a
That's-
situation which emerges as a result of its own order.
That's right.
All right. In various other contexts, we always say active
You have said that in
scrutiny,
several judgments. Malas.
eminent gravity.
Yes.
But assuming that is so,
Yeah.
and we place ourselves in the position in which the court was, say, immediately before the 27th,
Yes.
what would the court then have done? That, look, let the speaker decide. Keeping aside the issue of 2-day or 7-day notice.
Yes.
Let the speaker decide.
Yes.
So if we have to restore the position as it would have been, but for that order of the 27th, we would have said, let the speaker decide.
Yes.
Possibly, your argument would be, until the speaker is deciding, no trust vote. Let them take a decision first, and then, because the trust vote.
Because everything helped there after that happened because of this order.
But therefore, if you have to restore the situation as it stands immediately before the interim order of this court, we can restore it by saying that, well, the speaker has to take a decision.
Right,
as of
as
that
of
day.
date.
Yes.
Had they incurred a disqualification.
Yes.
But it would be very difficult for us to take over that function.
Malas, I don't mind, Malas. Let that deputy speaker decide. I have no problem with that. That's what happened in
Therefore, which deputy speaker?
the speaker, Malas, who was denied the right to continue with the disqualification. This has happened in the other case.
So then we restore a putative state of affairs.
Yes, your lordships have done
completely
that.
overtaken by events.
In Nabam Remia, your lordships have done exactly that. Exactly that. Because when I argued this before the Constitution bench then, I said, my lords, what is happening is you let things happen, and then you will tell me later that we can't reverse it. He said, no, we will reverse it.
Sibbal, then you support Nabam Rebia's course of action when it suits you. And when Nabam Rebia is creating a problem, you wanted to.
No, Malas, that's because there are two different issues in Nabam Rebia, Malas.
All right.
Well, I'm sorry, Malas. You can't put that argument.
No, we're not at all.
There are two different issues. Malas, in fact, I was wondering when your lordships are going to decide to refer it to 7, because this is a real problem. Because that's intrinsically at the heart of the matter, which is why I said you take it up as a preliminary submission. Because ultimately this can only be decided.
But Mr. Sibbal, look at the consequence. You today have a speaker. You have a speaker in a democratically elected house. Tomorrow you may have a speaker in parliament. Can the Supreme Court say, sorry, we are now overriding the mandate of this speaker? We will retrace our steps back to say now something which is 8 months ago, restore a speaker who is now no longer holding the office of the speaker, and we tell you, we now decide that somebody is the speaker.
He's still deputy speaker.
Huh?
He's still deputy speaker.
And ask that
But he's
speaker or
still deputy
deputy
speaker,
to take a consequence. I mean,
He's still deputy speaker. Malas, all right. Well, one second. Hold on. You got a lot of hurdles to cross. But anyway, let me.
you're all very seasoned constitutional lawyers, but you know what is worrying us.
No, I'm not going to.
You
I'm not going
understand
to
what is worrying us.
make a proposition that will in fact destroy the fabric of a constitutional structure that has been in place since independence, since we were a republic. I'm not going to do that. But see what has happened. First of all, the no stays. I mean, they are given time till 12th July. But more important, On the 29th, this court says that we will set aside everything that happens thereafter. See, Malas, where we are now. We say, please stay everything. Don't allow the trust vote to happen. Decide this matter. It could have been decided on the 12th of July. Then the court tells us, no, doesn't matter. On the 29th, all that is subject. Now your lordships are telling me, how can it be subject? Now your lordships are telling me, rightly maybe, that how can we go back on 27th? But that's exactly because of the two court orders. What do we do?
But the court order was also prompted by what your speaker did.
Yeah, I said, you stay. Don't allow them to take the oath. Don't have a trust vote. We said that. Then on 29th June, that order is passed. Thereafter, all matters are placed.
Had your speaker chosen to follow the law by giving them 7 days
No,
notice,
the law is Naban Rabia. The law is hollow on.
The court would have said, all right, go and respond to the
law is hollow on. I tell your lordship now, I can't in hindsight say what the court should have done was stayed everything, allowed them to file a reply and allow after 12th of June for the speaker to decide. What was the problem? There was no problem. But the status quo changed. Well, they were given time till 12th of July. All right, let them give time. Despite the fact that it is contrary to Holhorn, forget it. They should have been given time. They should have filed a reply. The deputy speaker would have decided, why allow the status quo to be changed? And that also, because a judicial order says, doesn't matter, even if the status quo is changed, we'll restore it back. So we had two judicial orders then. And now your lordship rightly puts now under the proceedings of the House, a new speaker has been appointed. But then you yourself said that we will deal with it. All that will be subject to.
So essentially, we'll therefore have to invalidate the trust vote which took place on the...
Because it was only on the basis of these 39
a trust vote which we will have to invalidate, a trust vote which never took place.
No. Even the trust vote that took place on 4th is subject to, Malaz. I'm sorry. All other actions are subject.
My learned brother just...
I'm sorry.
You challenge. Just what,
Yes.
on
Yes.
your submission, that as per the interim order dated 29 June, correct, all subsequent proceedings are subject to ultimate.
Yes, yes.
Now see, actually, we have to consider that. On 29th, you challenge the trust vote to be held on 30th June,
Yes,
correct? You challenge that only.
that's
on
correct.
29th,
That's correct.
correct? Now see the order, interim order, which is passed by this court on 29th.
Right.
See, please read it.
Yes, I'll read it. What's an order compilation, Millers? Let's see that.
That is, I think on page.
Page 7 of the
order
order
compilation.
compilation. Volume
Orders
17.
compilation, volume 1.
Volume 1.
Yes, I have it. PDF pages 7.
Order dated 29 June.
It starts, we'll just see, Millers.
PDF 8 at 10. Para 8. Operative.
I just read it.
This is the PDF.
Yes. Page Millers, the writ petition is ordered to be listed for hearing.
Para 8, maybe straight away you.
Right, having given a thoughtful consideration. That's the one?
Yes.
Yes, yes. We do not find any ground to stay convening of the special session of the Maharashtra Vidhan Sabha tomorrow at 11 a.m. with the only agenda of a trust vote. The proceedings of the trust vote to be convened on 30th shall be subject to the final outcome of the instant writ petition as well as the writ petitions referred to above.
Correct?
Yes, and the special session of the Maharashtra Vidhan Sabha shall be conducted. So as well as writ petitions referred to above.
Okay, but what
Writ petitions referred to above is that
was the subject to ultimate outcome? The proceedings of the convening the meeting on 30th. would be
I
subject.
agree.
Not all the subject.
Maharaj,
proceedings.
I don't dispute that. I'm saying,
The fact remains that on 30th June, for whatever reason.
I had resigned early.
Trust
Your Lordship is right.
at all.
Your Lordship is absolutely right. But Maharaj,
Your submission that all other, as per the order dated 30th June, all other subsequent will be.
Maharaj, I just asked myself a simple question. Had I not resigned, that trust vote would have happened and I would have, the same thing would have happened.
Correct.
Correct? The
That's
same thing happened on the 4th.
Take counsel.
The same thing happened on the 4th.
Provided the meeting would have been convened on 30th.
Maharaj, same thing happened on the 4th. The trust vote happened on the 4th. And that is also subject to, writ petition was filed. Your Lordship said we will consider that, that will also be subject to.
No, we were on your submission.
Lordship is right. I mean,
Technically,
technically, what my Lord is saying is absolutely right. I cannot have any two opinions. There can be no two opinions. But the fact is, in substance, it's the same thing.
that's it.
Whereas, yes, your Lordship is right. I mean, I can't get away from the facts that he said, what's the point of going to these people are going to vote for him. That's exactly what happened on the 4th. That's why we challenged the 4th. That's also the writ petition is here. So, are we going into the technicality or are we going into the substance of the matter? Whether these 39 could have voted in favor despite the whip. There is a whip issued, Maharaj, on the 3rd. Whip is issued on the 3rd that you vote against the trust vote. They did not. And who is the whip? Sunil Prabhu. Voted against the whip. So, Maharaj, where does it take us? It doesn't take us anywhere. So he votes against the whip, and Maharaj, Gogavale is then appointed. He can't be appointed by the speaker. And Gogavale, they have issued, speaker has issued notice to us. Those notices can't be issued. I can't be subject to any disqualification proceedings. And my notice has been given by the speaker to me to be disqualified. Your Lordship will strike it down on the facts. So all these issues will have to be decided. Maharaj, I'm sorry.
Which are the issues that you want us to decide?
That's exactly what I just showed. Let's give it to my lords. No, let's give it. I'm sorry, Maharaj, it's taken.
Responded yet.
Maharaj, they will have. Through, Madam,
Yes, yes.
what your lordships
That crucial.
might or might not wish to decide.
No. The crucial facts which you have.
It's not finished yet, Madam.
Told us, leading to the 22nd.
Yes.
I think those are completed, right?
Yes, those are completed. Then what happens thereafter, Madam, another letter is, Madam, the letter of 22nd.
To the notices on the 10th schedule notices.
That's correct, that's correct. And thereafter on 24th, another notice. Then on 25th,
We are aware of.
Mr. Sibbal, we were at page 55 of that.
you want me to
compilation.
finish that first,
So
Madam?
that, you know, that part is over
Quickly
just for the
indicate
sake
those
of
dates,
completeness. Let's,
All right, we'll do
Let
that.
me indicate those dates. and
Yes,
we
we'll
can
do
this.
let's go to page 55. We were at page.
Yeah, I'll
PDF
just
page-
go back to my document, Madam.
Seems like
The convenience compilation of,
Two, right?
Convenience compilation.
I got it.
2 at
we are
page
at 49, Madam. Now, this is that PDF 62. This is that document which your lordships have already read. Dated 22nd, I'm dated 21st, but served on 22nd at 11:30, which your lordships have already read.
This is the
Just
important.
let's make a note of it since we are
That's right. I'm not going to read it.
Relevant for Nabam.
page 62, right?
Except, Madam, the fact that they are the majority, no other cause was shown. So 179C, I've made my submissions on 197C already, Madam. So, and that, this is connects with Nabam Rebia, this document. So that issue is over. Then kindly come to, Madam's page, PDF, Madam 71. This only gives you, Madam, what is happening, 40 members from the MLAs in Assam. No dispute on any of this.
Then next.
And then is the disqualification petition filed on the 25th.
Page 62.
Well, that's at page 72.
Mr. Sibbal, page 62 PDF that we've just touched upon, notice to move a resolution. What does para 2 say?
At page 62.
Yes, please.
Yes, I just. Para 2 says, Malaj, we all respectfully submit that you no longer have the right to continue as Deputy Speaker, as you no longer enjoy the support of the majority of the House,
The
and
House.
more particularly the following
Is that
members of our
what you-
party.
Majority of the House.
Yes,
Is that what you're trying to, this is your emphasis?
yes,
That here
yes,
also the references to the majority of
in
the
the
House
House.
and goes on to say particularly the following members of the party.
That's correct. Because, Malaj, what is party means? The legislature party.
No, that's not quite correct, because my learned friend repeatedly says this. But every member of the Legislative Assembly and of Parliament is ex officio
Yes, yes,
member of the Pratidhini Sabha.
that's
We
correct.
are also part of that.
That's right. No
And
doubt.
everyone else
That's
One
overlap.
second. Hold on.
is appointed by the-
Hold on.
There is an overlap.
No dispute.
Aware of.
The 39 members of the legislative party are also members of the party. No dispute.
No question about it.
No, how am I? I'm not said anything
They have to
contrary.
have primary membership. of the
Yes,
party.
yes.
That's
I have not said anything against that. Only thing is that 39 members can't hijack the party.
That's all.
That we'll see. That's the issue. Of course, we welcome you.
No.
It's all right. No, let me continue, please.
Next.
So, Malas, your ladyship was right. Exactly, Malas. Then kindly come to
59,
59, Malas.
PDF 72.
No, first, Malas, yes, 71, PDF 71, page 58. Maha trouble for Uddhav, Hemanta meets Eknath, 40 MLAs in Assam. Photographs
Sorry,
there.
where are you? The Hindustan Times article.
News, Hindustan
yes.
Times article.
That's to show that it's
It
reported.
just shows, Malas, that, the surroundings are comfortable.
Relevant for the 10th schedule, no doubt. Not for a speaker, relevant.
Then, Malas, the notices.
inference.
Now it's the notices we don't have. No more Muller's documents. All kinds of statements have been made, Muller's, that we are following a separate party, but that's all happens in Assam. It's a given, Muller, so let's not go into that. So this is all, Muller, as far as the documentation is concerned. Now let's see, Muller, what the issues are. The first, Muller's, deals with Navam Rebia, basically, so that your lordships will have to decide. That is, does the Constitution permit an institutional hiatus by tying the hands of the Speaker in functioning under the 10th schedule through proceedings initiated by a member of the Legislative Assembly under 179C? Right? I've argued that your lordships will decide. All I can say in that regard is that if you allow that law to stay, it will be misused. It will be a new model of toppling governments. Safety valve for defectors. Now, the second, what are the consequences in law when members, whether in minority or majority, of the legislature party in the House act dehorse the political party and are contrary to the directions of the political party and assert their separate identity by forming a separate group within the legislature party in the legislature? Squarely, Malas, that's an issue. Squarely. That can, in any legislature, X number of people form a separate identity and say, we'll not listen to the party, we'll decide what to do.
That you've been arguing yesterday.
Next, third, will a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have per se incurred disqualification under para 2 of the 10th schedule? There's no evidence to be led here. Admittedly, there is a whip, Sunil Prabhu, on the third, saying vote against the trust vote. Admittedly, on the record of the House, they voted in favor of the trust vote. Even by that time, Gogavale had not been appointed by the Speaker, though the Speaker has no right to appoint Gogavale. He appointed Gogavale on the third evening, which he can't do otherwise, but that's another matter. So, Malas, what is there for the Speaker to decide? There's a violation. The vote is on the record. You're not usurping anything. You're only declaring.
This question is incoherent. This issue is incoherent. What is the logical follow-up? Then
No,
the Speaker will say it's per se case.
I'm sorry?
Speaker will say it's a per se case.
Yeah, I hope so.
You are.
I hope so, Malas. I hope so.
Different matter. What you're trying to say in 3 is, in per se cases,
Yes.
should the court not decide?
Yes,
what
that's the point.
That's
the-
that's what.
That's why I put per se there, Malas, only for that reason.
God.
So it is incoherent.
Well, we we have to ultimately persuade you, Malas, so we have to. I always say the court on your side, there's no point arguing. And the only way to have the court on your side is to be as reasonable as possible, though politics is essentially unreasonable. The art of politics is to make the unreasonable look reasonable.
Necessary. Politics can be very reasonable also.
3, will a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have per se incurred disqualification under paragraph 2? Then 4, can a group within the legislature party asserting their separate identity and acting dehorse the political party or contrary to its directions have the constitutional authority to alter the leadership of the political party in the House or the whip appointed by the political party in the House? Directly in issue. Because of those documents, Malas, I've shown to your lordships already that you are removed from Assam, you are removed as the chief whip, and I continue to be the party and you are removed as leader. I continue to be the group leader. 5, given that an elected government should be allowed to serve its full term, this is now a constitutional premise, Malas, on the basis of which I made this proposition. Given that an elected government should be allowed to serve its full term as a matter of constitutional law, can a group within the legislative party asserting a separate identity dislodge an elected government while proceedings for disqualification under the 10th schedule are pending, That is before the speaker decides on the issue of disqualification. Directly an issue. Well, what you are doing in this process is sidetracking the disqualification proceedings, toppling a government, and then saying, now my speaker will decide. Actually, the constitutional premise and every constitutional authority should in fact help in ensuring that an elected government continues to be in power. Whereas it's something that I'm going to argue later, but I want to just tell your lordship something very interesting. Whereas a governor has to decide to administer the oath of office. So 30 people go to him, 20 people go to him. The governor must first know which party they belong to. Either it's a post-poll alliance or a pre-poll alliance. Right? So the governor must first ask them, which is that party? Now, their position, 39 members' position is inchoate. They can't represent the SHIVSENA. This is the first time this issue has arisen in this country. So, how does the governor decide that I'll administer oath of office? There is no party before him. I'm just touching it, this is an issue that your lordships will have to consider. So, let's come to 6. Should the governor, who is constitutionally obliged to sustain the continuity of an elected government, change the status quo by allowing for a change in government before disqualification proceedings are decided by the speaker? Then next, whether the governor can swear in as chief minister a person against whom a notice for disqualification has been issued by the speaker acting as a tribunal under the 10th schedule and is pending adjudication. What is the impact of pending disqualification petitions on the ability of members to participate in a test of strength on the floor of the House when their vote would have the effect of toppling the government? I can understand in a situation, that clearly doesn't matter, the outcome would be the same. But here the hard facts are, their vote topples the government. So you have allegedly, according to me, a member who should be disqualified, voting to topple an elected government without the governor asking him which party you belong to. Without the governor, even finding out for himself. Or the governor saying, look, there is some disqualification petition. By this, an elected government will be toppled. Let's stay our hands. We will not administer oath of office till the disqualification is decided. He can say that. Should he say that? Should he not say that? That's an area where your lordships have never looked at, so to say. Well, obviously, it's premised on constitutional morality. Then, can a constitutional court, in a matter relating to disqualification of the 10th schedule, decide the matter on its own without referring the matter to the speaker for decision? And if so, under what circumstances? Right? Directly what my lord put to me, and we are aware of it. If the decision of the speaker that a member has incurred disqualification under the 10th schedule relates back to the date of the action complained of, then what is the status of proceedings that took place during the pendency of a disqualification petition? Because it relates back, he is the chief minister. What do we do? Which is why the time is of the essence. What is the impact of removal of para 3 of the 10th schedule? I've already argued that. In what circumstances do the speaker recognize the whip and the leader of the political party? I'm arguing that. What is the scope of powers of the commission with respect to determination of a split? That's something I'll argue later. This is, according to me, the issues that your lordships might wish to look into. Now, let's kindly have a look at my overview document, which is document for our submissions, petitioner submissions. A. A, that's correct. And kindly have a look at outline and over PDF page 5 overview. Well, your lordships may skip that. I want your lordship straight away to take you to the issue of the whip. Chapter 7. Yes, of whips and the role of political parties.
Which portion?
Which,
This is that PDF page 70, madam.
no, which file?
Of the written submissions of petitioner, but the same document.
Petitioner's
A, written submissions A, madam, of the petitioner. Page 70.
1 minute.
I hope to finish today, madam, so that I don't take too much of your lordship's time.
Did you say it's PDF page?
Page 70. madam.
70.
70.
Sorry, 70. Yes.
Chapter 7. What is the scope and power of the Speaker to determine the whip and the leader of the House? What is the interplay of the same with respect to the provisions of the 10th schedule? Well, it's, the petitioner respectfully submits that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip and also the leader. Lordship, Justice Shah doesn't have it?
Yeah, now.
Petitioners respectfully submit that the leadership of the original political party is exclusively empowered to determine which member of the House shall be the whip and also the leader of the House Legislature Party. The Speaker is bound to recognize the person who are communicated by the leadership of the original political party to be its whip and leader of the House Legislature Party. The Speaker's role in this regard is merely administrative in nature. The Speaker cannot abuse his role to defeat the spirit and intent behind the provisions of the 10th schedule. Now, it is submitted that the respondent's case is hinged on a legal misconception that the whip under paragraph 2(1)(b) of the 10th schedule can be issued, changed by a majority of the members of the legislative party, which is what they did on the 22nd of June. The defense is in the teeth of the plain reading of 2(1)(b), which my lord has already read, Malas. So, Malas, that's exactly what we were wanting to do. A bare reading of the aforesaid provision would show that the framers of the 10th schedule were conscious that the disqualification was to be incurred for violation of the whip issued by the political party or any person or authority authorized by the political party. There is no reference at all to the legislature party in para 2(1)(b) of the 10th schedule. This distinction between political party and legislative party is also borne out from a reading of paragraph 1(b) and 1(c) of the 10th schedule, which brings out the difference between the meaning ascribed to the legislative party and the original political party. The respondents in defense have sought to intermingle the definition of political party with that of the legislative party and have sought to extrapolate the legislature party in the place of a political party in 2(1)(b). It is further submitted that para 1 of the 10th schedule makes a clear distinction between the term legislature party and original political party. The term legislature party is defined as the group consisting of all the members of that house for the time being belonging to that political party. And the term original political party is precisely defined as the political party to which a member belongs. Further, the definition makes it clear that the said term is specifically defined for the purposes of 2(1) of the 10th schedule. In this regard, Kuldeep Nayyar's case, you'll kindly have a look at paragraph 4, just the quote there. Authorities are certainly not wanting, which indicate that courts should interpret in a broad and generous spirit the document which contains the fundamental law of the land or the basic principles of government. Nevertheless, the rule of plain meaning or literal interpretation described in Maxwell's interpretation of statutes as the primary rule could not be altogether abandoned today in interpreting any document. Indeed, we find Lord Evershed, the length and detail of modern legislation has undoubtedly reinforced the claim of literal construction as the only safe rule. It may be that the great mass of modern legislation, a large part of which consists of statutory rules, make some departure from the literal rule of interpretation more easily justifiable today than it was in the past. But the next is very important. But the object of interpretation and of construction which may be broader than interpretation, is to discover the intention of the lawmakers in every case. C. Crawford, the object can obviously be best achieved by first looking at the language and used in the relevant provisions. Other methods of extracting the meaning can be resorted to only if the language used is contradictory, ambiguous, or leads really to absurd results. This is an elementary and basic rule of interpretation as well as of construction processes, which from the point of view of principles applied, coalesce and converge towards the common purpose of both, which is to get at the real sense and meaning, so far as it may be reasonably possible to do this, or what is found there laid down. The provisions whose meaning is under consideration are therefore to be examined before applying any method of construction at all. And 2.1a and 2.1b makes it very clear. Violation of the whip and voluntarily giving up membership. And well, as your lordships with experience knows what act amounts to voluntarily giving up membership. We endorse and reiterate the view taken in the above quoted paragraph in the judgment. It may be desirable to give a broad and generous construction to the constitutional provisions, but while doing so, I'll just read this, to the rule of plain meaning or literal interpretation, which remains the primary rule, has also to be kept in mind. In fact, the rule of literal construction is the safe rule unless language used is contradictory, ambiguous, or leads really to absurd results. I'll continue after lunch.
We'll come back after.
Yes.